So here we are back in Law 157, LLM 457, and we're in part two of our lecture on arbitration and expert determination stroke expert appraisal. I'd like to move on to objective number 2, but before doing that, on T8 in the tile there, I'd like to refer you to some correspondence that I had with Michael McHugh, and you'll see there are copies of letters and emails that he sent me on the 13th of October 2008, on the 27th of September 2011, and on the 13th of August 2015. There's 3 pieces of correspondence. Now, at the time of his practicing, Sir Lawrence Street was recognised as probably the leading mediator in Australia. Since his demise, it would be fair to say that Michael McHugh has probably taken over that role, and he is still practicing since his retirement from the High Court, and I don't know how much longer he'll be able to go. But these pieces of correspondence are very, very interesting from our perspective, because they give you an insight into actual practitioners, not people that necessarily are theorists or people that are academics or people that write from an academic perspective. In these correspondence, you are getting it from basically the horse's mouth, the top mediator in Australia. I'd like to take you through a couple of, well, I'd like you to read all of the correspondence. I'm not quite sure how it fits into our objectives, but I've put them into T8, and they sort of stand alone a bit, and they stand right across the unit so far as mediation particularly is concerned. He says in his 2008 letter, in a large majority of cases, the approach in mediation that I do, the great bulk of which are commercial mediations involving millions of dollars, depends on whether the parties are in a continuing relationship and whether the only bargaining tool is money. Where an insurer or a litigation funder is involved, invariably they are only interested in positional bargaining and have no wish to get involved in interest-based bargaining. So there you see how he refers to the 2 forms of bargaining that we had looked at and puts them into the context so far as commercial mediations are concerned. And he points out that interest rates bargaining, they regard it as totally irrelevant and a waste of time. That is, the litigation funders and the insurers. So litigation funders are people who are prepared to fund, usually a plaintiff, to proceed with litigation on the basis that they will be recompensed according to the terms and conditions of the agreement, which sometimes may involve a percentage of whatever verdict they come up with, if they're successful. Michael McHugh goes on, they regard money as the only interest or issue. The result is that the defendant wishes to pay as little as possible and the plaintiff wishes to obtain as much as possible. If you go down, miss the next 4 lines, you'll see he says, in defamation cases, the terms of an apology or retraction may also persuade the parties that an interest-based approach is the best approach. But as a rule, I find that the classic mediation model has little scope when the parties are not in a continuing relationship and money is the principal issue in dispute. Now, you recall here he makes reference to the defamation and the terms of an apology or retraction. Courts don't or can't enforce those, but you can do it by agreement through a mediation settlement. And this is the difference here, as he points out in the first part of his of this paragraph, where there's no continuing relationship. In these commercial mediations, the only bargaining tool is money. So if we go to the next paragraph, you'll see where there is a continuing relationship, the parties themselves can often, but not always, be induced to play a more active role in the mediation instead of leaving it to their lawyers. Often in this class of mediation, interest-based bargaining is appropriate and accepted by the parties. So you can see there he draws the distinction between where there is a continuing relationship and when there isn't a continuing relationship. You're more likely to get interest-based bargaining where there is, in his experience. Remembering that he's doing this on a full-time basis. So if we go to his email of the 27th September 2011, in the second paragraph he says, more and more I think that one of the most important skills of the mediator is to dampen the expectations of the parties by reality testing in those situations where there is no continuing relationship between the parties, which is the situation in most cases arising in a litigation context. You remember last week we talked about dampening the expectations, and we looked at the example of the witless barrister that told his client the case was worth 700 or 800 and the top of the range was, say, 450. And once a client hears that, it's very hard to shift them, even though it's bad advice. And it's interesting that Michael McHugh picks up on this issue of dampening expectations, and he sees it as a mediator's role to dampen expectations. It seems to me that one of the reasons so many mediations settle towards the end of the day, and this is interesting, rather than earlier in the proceedings, is that parties become more amenable to compromise and settlement only when they recognise that they are not going to get the result that they anticipated at the start of the mediation. It often takes a long time for that realisation to surface, or you could say to sink in. Without assistance from the mediator, the parties usually have the difficulty in seeing that their respective cases have problems. So some might say that, and this is his style of doing things, he tends to be a little bit more interventionist. Second last paragraph, he says, I refrain from expressing an opinion about the prospects of success. I prefer to lead each party to a realisation that the party's case has problems, usually by probing questions concerning apparent weaknesses in the party's case. Often I will ask a party in the presence of the other party to recount the other side's case and then invite the opposite party to correct or add to that account. So that's an interesting ploy when you think about it. I find that this technique assists the party to better understand the risks it faces if the matter is litigated. It forces the recounting party to face up to the other party's case. Another technique that I use is to ask the party to assume that it has gone to litigation and lost the case. I then ask the party to give 5 reasons why the judge found against that party. All of these techniques are directed to getting each party to take a realistic view of its prospects if the matter is litigated. Another way of saying that, to dampen their expectations. To dampen their expectations. He then finishes up by saying, increasingly, I find that solicitors want mediators to be interventionists and are critical of mediators who make no effort to dissuade a party from the position it has adopted. As I said, I refrain from expressing an opinion on the merits of the party's case, but I do engage in reality testing of a party's position. So he doesn't give them what he thinks the case is worth. He just probes and probes at the weaknesses in their case. And finally, in his letter of the 13th of August 2015, he says, in mediation theory, mediation is a win-win process. In mediations arising from litigation, that is rarely the case because of the uncertainty of litigation and in many cases the power imbalance between the parties. These factors of uncertainty and power imbalance, together with most litigants being risk-averse, frequently lead to injustice in an absolute sense. This is particularly so where one party is a government, a public authority, a liquidator, you might say an insurer, or a receiver who has vast financial resources and no skin in the game, and the other party is a private citizen of limited means. Frequently, says Michael McHugh, the private citizen has strong prospects of winning the litigation, but faces ruin if he or she loses. Consequently, the private citizen will settle for, quote, an unfair amount rather than risk ruin. Now, I was quite taken aback when I read that because that wasn't my experience. But he's talking there about commercial mediations, where big amounts are at stake, whereas the most of my experience was in personal injuries. And yes, a plaintiff did face maybe not financial ruin, but certainly a lot of financial harm if they lost a case against an insurer and the insurer chased them for the costs. That would be the award that was against them. But it mightn't necessarily mean financial ruin. And there's usually plenty of scope for a plaintiff, a single citizen, against an insurance company or against a government agency or some large corporation like BHP or something like that, to exert pressure from the point of view of their own, I would say probably loss of face, the fact that it may create a precedent. We had a case once, I remember, of a fellow that was delivering 44-gallon drums of avgas to the aerodrome at Forbes, and they what he had to do is he had to roll the drums to the edge of his truck, and they put tyres on the old tyres on the ground, and he tipped them over onto the tyres, and then he'd get down on the ground and then lift the 44-gallon drum up. And a 44-gallon drum of fuel is heavy, but there are techniques in doing it. Anyway, he was found dead in his truck outside the next delivery point where he had to go to. And we argued that it was an unsafe system of work and that the employer was negligent. And it went to a hearing before Mr Justice Yeldham, and we had to call a cardiologist and blah, blah, blah. And we won the case. And it was probably because it was comp to rels also, because the widow was suing. But what was interesting was that the insurer initially said that they were going to appeal straight away because they didn't want that case reported, because they thought it would open up floodgates against them. Anyway, we waited and waited and waited. I think it was 21 or 28 days. And despite all the brouhaha when the decision came out, they chose not to appeal. For some reason, I don't know, maybe a commercial reason, or they took the risk. The case wasn't reported. And so they, as it turned out, they made the right decision. But they were worried. They were worried. So plaintiffs can put pressure on, insurers too. So it's interesting that Michael McHugh is looking at commercial mediations, and I have no doubt that what he says is correct in that vein, but I'm not sure that it is correct so far as necessarily all areas of litigation. Anyway, have a look at those letters. They are examinable, and give some thought to what he says, and I'd be interested to hear if you've got any thoughts yourselves. Some of you are in practice. You might have some thoughts about it. So we'll move now to the objective number 2, which is the ethical role of arbitrators who sit as an amiable compositeur. Now, I think this is a fascinating area, a really fascinating area so far as dispute resolution is concerned. It's printed in black and white that if an arbitrator sits as an amiable compositeur, he will or she will decide the case on the basis of what is fair and right. One might have thought that they would do that anyway. But, the point about it is, and this is why it's really interesting, the law may be against the arbitrator. The arbitrator may see something that is fair and right, but the law may be against the arbitrator. And this is why this notion of the amiable compositeur is really interesting. I'll take you to the definition, which is in the 7th edition, 2026, LexisNexis Australian Concise Legal Dictionary. And you'll see there that it says that a person, an amiable compositeur, is a person appointed as an arbitrator who may, by agreement of the parties, so they have to agree before the arbitration starts, settle the dispute on the basis of what is fair and right, subject to the rules of procedural fairness, which means that both sides have got to be given a fair hearing and know what the issues are, and the provision of the arbitration agreement, rather than by applying the settled law of a legal system. So the parties agree that if the arbitrator thinks that something is fair and right, even though that is contrary to the settled law, the parties agree that the arbitrator may find on that basis. And that's reflected in the Commercial Arbitration Act of New South Wales and Victoria and right around Australia in section 28, subsection 4 of the Commercial Arbitration Act of 2010. 28.4 says the arbitral tribunal must decide the dispute if the parties so agree in accordance with such other considerations as are agreed to by the parties. So it doesn't actually mention amiable compositeur, the Act, but that's the legislative support for an arbitrator to be able to sit as an amiable compositeur. So the practical law US says that an amiable compositeur, it's when an arbitral tribunal or arbitrator is authorised to act without being bound to apply strict rules of law and is free to determine any question that arises for determination in the course of the proceedings under an arbitration agreement by reference to considerations of general justice and fairness. If you wish to agree on that before you go into an arbitration, and obviously there'd be pros and cons, so who knows? It might be to somebody's advantage, it might be to somebody's disadvantage, but nevertheless, it is there. And if you look at the rules of arbitration, the international rules which we've adopted, they talk about, in the Australian Centre for International Commercial Arbitration, which is called ACICA, A-C-I-C-A, which is a good one for your glossary, Australian Centre for International Commercial Arbitration, paragraph 43.2 says, the arbitral tribunal shall decide as amiable compositeur only if the parties have in writing expressly authorised the arbitral tribunal to do so, and if the law applicable to the arbitral procedure permits such arbitration. And then also in the expedited rules, a similar sort of clause set out by ACICA expedited arbitration rules. Now, I don't have a lot of experience in arbitration, so I can't give you any stories or insight to it, but I am fascinated by it because I think it's one of the few places where you get, from a jurisprudential perspective, you actually get some sort of authority, some sort of direction, you know, to fairness and rightness, and not necessarily get bogged down in the law as we know it. There is one difficulty that it does create, and I don't know how the courts have handled this, but it does create difficulties on appeal. That is to say, if a arbitrator says, I'm deciding this particular issue as an amiable compositeur, and a party wants to appeal that decision, I don't know where that goes. I understand. All I know is it does create difficulties. And what's interesting is Sorden doesn't really talk about amiable compositeur. I'm not sure why, but so I don't have any authority to say. All I do know is that I have read that it does create difficulties on appeal. I'd now like to go to an absolutely, what I think is a fascinating area. That is the issue that is set out in number 4, that is analysing the genuine steps prerequisite procedure to litigation in federal courts, and contrast this to the New South Wales courts. Okay, so the ADR in the federal courts is governed by the Civil Dispute Resolution Act of 2011 Commonwealth, the CDRA, which requires parties to a civil dispute to take, quote, genuine steps, unquote, to resolve their dispute prior to instituting proceedings in either court, that is the federal court or the Federal Circuit Court. Now, genuine steps are described in Section 4 of the CDRA Act as steps that constitute a sincere and genuine attempt to resolve the dispute, having regard to the person's circumstances and the nature of the dispute. So genuine steps are described in Section 4 of the CDRA, that's the Civil Dispute Resolution Act of 2011 Commonwealth, as steps that constitute a sincere and genuine attempt to resolve the dispute, having regard to the person's circumstances and the nature of the dispute. And I always think it's not a good idea to use the same word in your definition as the word you are defining. So they say the genuine steps are a genuine attempt. I think they should have used another word there. Okay, so if we go to Section 4 of the Act, the CDRA, remembering that this is 2011, it's now 2026, 15 years later. In Section 4, it says genuine steps to resolve a dispute is the heading. Paragraph 1A, for the purposes of this Act, a person takes genuine steps to resolve a dispute if the steps taken by the person in relation to the dispute constitute a sincere and genuine attempt to resolve the dispute, having regard to the person's circumstances and the nature and circumstances of the dispute. Subsection 1. Examples of steps that could be taken by a person as part of taking genuine steps to resolve a dispute with another person include the following. So it sets out examples of what it understands, what the legislature regards as genuine steps. A, notifying the other person of the issues that are or may be in dispute and offering to discuss them with a view to resolving disputes. Now, that might sound very, very, you'd think that's pretty simple and very straightforward, but there used to be a philosophy of trial by ambush. If you were going to sue somebody, you didn't tell them anything until you hit them with a letter of demand and then followed up with a statement of claim. And it was known as trial by ambush. So you kept the defendant in the dark. Well, that's all gone now under the Federal Act. B, responding appropriately to any such notification. So it applies to both parties, not just the plaintiff. C, providing relevant information and documents to the other person to enable the other person to understand the issues involved and how the dispute might be resolved. D, considering whether the dispute should be resolved by a process facilitated by another person, including an alternative dispute resolution process. E, if such a process is agreed to, agreeing, subsection 1, agreeing on a particular person to facilitate the process and attending the process. And F, if such process is conducted but does not result in resolution of the dispute, considering a different process. G, attempting to negotiate with the other person with a view to resolving some or all of the issues in the dispute or authorising a representative to do so. Now, in some senses, some of the criticism of that is that you are providing the defendant at a very early stage with all your possible ammunition in a case that might or might not settle. And you're putting yourself as a plaintiff at a disadvantage. But this is the whole basis of this legislation, is to bring things to a head very early on. The trouble is that often you don't know how much a case is worth until you have really investigated it and had your client properly assessed, whether it's a personal injuries claim or whatever, and that you've got all your reports together and what are the ongoing or permanent disabilities. It's very hard early on. So there is a balancing act here. You don't want to prejudice your client by disadvantaging them too early. But on the other hand, if you're going to commence proceedings, you've got to go through these genuine steps. Otherwise, the court will disallow your process to go any further. So it is a difficult professional balancing act that you've got to really sort of watch very closely. So when you file your process in the court, there is a form that you have to file as the applicant, assuming you're the plaintiff. You have to make a statement and you have to outline the steps that you've taken to try to resolve the issues in the dispute between you and the respondent in the proceedings. And if you don't do that, or if you do it inadequately, then you can get an order against you. The insurer or the defendant or the government agency that you're suing can get an order against you personally as the lawyer to pay the costs. You can't get it from your client. So it's something that I haven't actually practiced in this regime when this has been party to it in New South Wales. I'll get to New South Wales shortly. It hadn't been implemented. but it has, I understand from what I've read, had a significant effect on resolving cases early. Now, if you go to page 172 of the custom publication, this is Jeremy Gormley's excellent paper regarding changing dispute culture, the Civil Dispute Resolution Act. You'll see it says there that the Civil Dispute Resolution Act of 2011, in all its elegant simplicity, brackets, it only has 19 sections in total, does no more than require the parties to take genuine steps to try to resolve their dispute before they commence their legal action in court. And it gives examples of what steps might be. If the matter cannot settle and court action commences, the parties must report the genuine steps they took in a document called the Genuine Steps Statement. It's filed with the initiating process, and a respondent must reply. And then he points out what some of the steps are. Now, I'll leave you to read the paper, but there was, or has been, a significant reduction. Insurers, defendants, respondents, they all love it. Plaintiffs, I think, have got to play a very careful game, and that is to say, don't start your proceedings too early. Sometimes there are, like in motor vehicle claims and things like that, there are steps you've got to take within short periods of time, otherwise you can be out of time, so you've got to be careful of that. But you've obviously got to balance your client's best interests with the regime that's in place. Now, so what happened in New South Wales, you'll see there's in the same year, 2011, the New South Wales government postponed their pre-litigation reforms. You'll see there the New South Wales government on their press media release dated the 23rd of August 2011, the New South Wales government will postpone the introduction of laws that require parties to take reasonable steps. So their test was reasonable steps, the Commonwealth was genuine steps to resolve their disputes before they commence court proceedings. New South Wales Attorney General Greg Smith SC announced. And if you go down fourth paragraph, however, since the laws were passed last year, concerns have been raised by a number of key stakeholders that the provisions may have unintended consequences. They postponed them for 18 months. That was 2011, the long 18 months. But I'd be interested to know who the stakeholders were. I can't imagine the insurers were against it. Now, this was, from my recollection, a government that gave it a go and then didn't proceed with it in the same year that the feds did proceed with it. And all the research says that it's had a remarkable difference and a significant difference, and reduced the amount of matters that have been litigated, because matters have been resolved at an early stage because of the genuine steps statement that was made and the mediations that were imposed and blah, blah, blah. So I can't think, I mean, a Labor government you would think would be in favour of, a Liberal government you would think would be in favour of the genuine steps, because it gives the insurers and the defendants early notice. Trial by ambush is off the, it's off the plate. You can't use ambush tactics that we used to use in the past. I find it quite mysterious as to why New South Wales hasn't implemented this. We've had a Labor government in for a long time. Perhaps they think that it's in favour of their constituency not to bring it in. But on the other hand, they complain about the cost of the appointing more and more judges because the lists are not really shortening as they would like. So there you are. But anyway, so we've got two completely different situations in New South Wales and in the federal jurisdictions, in the federal courts, and we can't really understand why that is the case. All right, so that's all I want to say for that, and looks like we're right on time to finish up at this stage. Next week we'll be doing what I think you'll find is a fascinating area, and that is the ADR hybrids, some fascinating forms of dispute resolution that have been developed over the years, and I think you'll find it very, very interesting. Are there any questions?
Yeah. Just in regard to those emails.
To Michael McHugh.
Yeah. The unattractive certainty that was discussed about parties wanting to settle in a mediation because they can't afford litigation and they feel pressured into that. In the custom publication, it states that it's actually it suggests that the mediator also puts pressure on the parties to settle and not go to litigation.
Yeah, I mean, there's so many different types of mediator. Yeah. Michael McHugh says that all he does is probe, and he doesn't put a value on cases. He just asks them questions. He keeps asking them questions. But there would be mediators that do that. Gotcha. But it's not, put it this way, it's not an orthodox form of mediating. Yeah. The mediator should only be ensuring that the process is followed. Yeah. It's the parties that have got to make the decisions. But human nature, different styles, and also it depends sometimes in the jurisdiction. Sometimes the parties may even ask, what the mediator thinks. But even so, in that instance, my advice would be don't get involved because if they're unhappy Vegemites and they'll go home, the only thing they'll remember is the figure that the mediator mentioned, and if they settled for that and they're unhappy, they'll blame him or her. Yeah. So, I mean, you've got to play a middle course. You've got to play a middle course. Yeah. That's all right. Yeah. All right, so that's the end. That's the end of this lecture.